I just want to touch on the fact that there is a difference between the independent contractors and employer relationship. We've mentioned contracts as well. What can someone do if they are employed as an employee but they feel that they're being treated as an independent contractor? What can they do, Paul?
Probably the best avenue. There's legal advice is always available and recommended at some stage, but initially at least probably a phone call or a contact with the Fair Work Ombudsman would be useful.
And how can they help?
Well, they will be able to give some general advice based on the person's circumstances, and then perhaps then based on that advice be able to refer them to somebody else. So, but the Fair Work Ombudsman will be able to answer a lot of their questions as to what their entitlements are.
Paul, there is also a trend that's happening, reverse to what Emily asked. Some employees are identified as contractors, so there's no employment agreement, but the employer and the employee is of the understanding to a certain level that it's an employment contract. But what it does is it prevents employee receiving the benefits as an employee, and difference between sham contracts and that situation, how a person identifies himself as an employee or a contractor. The same question was raised, but if you could elaborate on that, please.
Yep. So I think I'm assuming what you're talking about there with the entitlements, the benefits, so annual leave and leave provisions, yes, and then taxation and superannuation. So what sham contracting means is that a relationship has been set up where the employer, usually the one, he's trying to impose it on the employee with ignorance of the situation, and says, well, you're actually a contractor, but in reality, in factual, practical reality, they're actually an employee, so that they're missing out on those entitlements. So it's a cheaper way for the employer to do it, because they don't need to pay the entitlements, and they can work them 365 days of the year because they don't get annual leave. And so what that employee should do is contact the Fair Work Ombudsman initially, again, the point of contact, to see what their rights and entitlements are, and then what they can do about it.
I guess there's a fine line between
an independent contractor, and it's a very, very difficult question. The issue's gone to the High Court on many occasions, and in the course of that happening, many judges have said no, they're an employee, many judges have said no, they're a contractor, so reasonable minds can differ.
So it could go either way?
It could.
Depending on circumstances.
Yeah.
One useful tool that is available, and it's not a substitute for legal advice, but the Australian Tax Office, for tax purposes, does have a table on their website where you it has a lot of different of the criteria, and you can tick sort of, yes, that applies to me, or no, that doesn't apply to me, and you can sort of see where you stack up. And that might be useful for people as a guide, whether they should follow it up further and seek further advice.
Great. So with the Fair Work Ombudsman, it sounds like they provide some information. Can they give any advice?
Well, I think that by the nature of what they say, it is some advice based on the person's circumstances, and it is advice based on what they've been told. So sometimes somebody might give some or present some facts that are relevant and then leave out inadvertently some facts that are not relevant. And so therefore, the Fair Work Ombudsman can still only provide the advice based on what they're told. Great. So they do give some advice.
Great.
Just on a slightly different angle, some employees are not sure whether they're paid superannuation. What's the employer's responsibility in relation to superannuation, and how can the employee find whether he or she is being paid superannuation?
The first point of call would be to contact the employee's superannuation fund, so they can contact them to find out if any contributions have been made. Keeping in mind that an employer may not make them every month, they might be made quarterly, so factoring that in. Otherwise, if they haven't been making contributions, then they need to contact the Australian Tax Office.
It's a must to pay superannuation by the employer, I guess.
Sure, I believe there's penalties involved on an employer who doesn't do it.
Right.
Yeah.
Yeah, it'll be subject to an interest penalty charge.
And what if someone feels as though they're being treated unfairly at work? What avenues are open for them? Should they directly approach their employer first before taking any legal action?
Yeah, I think that they should. I mean, if what we would always say is that if the problem can be sorted out or resolved amongst yourselves, that's always the better. Obviously, that only goes to a point where then the problem can't be resolved. Then some legal advice may need to be sought. Again, the Fair Work Ombudsman can help in those sort of situations because the employee may just be coming from an avenue of being slightly ignorant of, of what their rights and entitlements might be. So the Fair Work Ombudsman might be able to set them on the right track.
Right. So, but that might just be their employment relationship. What about termination? What if someone's been unfairly terminated from their employment?
Well, sure, that's opening up another big field. Obviously, you're talking about probably unfair dismissal. So there's obviously legal advice that can be sought in that situation. The Fair Work Ombudsman, again, can give some advice, plus the Fair Work Commission. Unfortunately, the Commonwealth Government saw fit to establish two bodies with very similar names. So we've got the Fair Work Ombudsman, which basically advises generally on rights and entitlements, and the Fair Work Commission has more of a role in unfair dismissal, and it's more of a tribunal.
Rebekah, give us some examples on unfair dismissal situations.
Sorry?
Give us some examples on unfair dismissal.
Okay, so what the Commission will look at is whether there's a valid reason and whether it's been procedurally fair. So valid reason can be anything sort of up to something really serious or serious misconduct. Can be, performance management as a result of an employee being warned about the risk of being terminated and then failing to live up to the expected standards, all the way to theft, turning up unsafe at work and providing a risk to other employees and themselves. So they're sort of examples of what may be a valid reason. Procedurally fair really means all the factors that the Commission considers are whether they've been given an opportunity to respond to any reasons related to conduct or performance, whether they've been refused the chance to have a support person, things like that.
On the opposite, if an employee wants to leave, what's the protocol? What should be followed?
If an employee wants to leave,
yes.
There's generally notice provisions.
Yes.
So perhaps in a written contract there might be something that generally, there might be, say, 4 weeks notice that's required so they can resign voluntarily. Or, again, it might just be a matter of some negotiation with the employer to say, well, look, can I leave a bit earlier? Can I give you 2 weeks' notice? I've got to go somewhere in 2 weeks, or I've got to go overseas or whatever. So that can be negotiated too.
So what kind of notice should you give? Should it be in writing? Can you do it verbally? What's the best way?
Well, I think with these things, as it is with generally, it's always best to put it in writing. Yeah.
Yeah, I agree. The length of period really depends on how long you've been working there. So if you've had less than 12 months service, 1 week, you can give more, obviously, rather than less if you prefer. Same with an employer, they can give 1 week if you have less than 12 months service, but may choose to give more and be more generous. But they generally increase depending on how many years you've worked with an employer.
And are you entitled to anything once you have ended that employment relationship?
You'd be entitled to payment for any unused annual leave, assuming you've accrued it during your employment. Obviously, casual employees don't accrue annual leave, and if you don't work out the notice period, or if you're asked not to work out the notice period, then there may be some discussions around that.
And there may even be the possibility of some long service leave to be paid.